Oh no, malpractice in medical imaging? How could this be? Hi, this is Mark Struthers, and today we'd like to talk about tips for avoiding a malpractice suit in medical radiography. This presentation in no way should be considered legal advice. This presentation is simply some observations about medical imaging and malpractice suits as they impact a medical imaging department. Every facility and every person and every lawsuit is unique. So you may take these observations and generalizations with a grain of salt, or you might actually adopt some of them. The high stress, fast paced, and chaos of the medical field can have an impact on the professionals working, and at times errors are made. For ancillary staff, such as medical imaging technologists, they rarely get sued. It is usually the doctor. The doctor is responsible for all those under their supervision. But what we're looking at is not who should be responsible, but who could be responsible. And as a licensed healthcare professional, you could be responsible in a malpractice lawsuit as well as the physician. A licensed healthcare professional, a licensed healthcare facility or agency, or even an employee of the facility can be held responsible for a malpractice lawsuit. Any healthcare professional who acts negligently can be held liable for medical malpractice. Study this graphic to give you an idea of what the probability is that you will be involved in a malpractice suit, because there are 17,000 or more that are filed each year in the United States. The type of physician who gets sued is mostly neurosurgeons, cardiovascular surgeons, general surgeons, orthopedic surgeons, plastic surgeons, gastroenterologists, and OB/GYN doctors. Surgical errors make up approximately 34% of medical malpractice cases. Well, let's take a look at the cost of these type of claims. We'll look at medical expenses, settlements, and judgments. Medical expenses are the costs incurred by the patient for treating their injuries or illness caused by the alleged malpractice. Settlements and judges are what are awarded to the plaintiff by the court or agreed upon by both parties. If you are sued, you are the defendant and you'll need to get a lawyer to represent you. So let's take a look at the cost of a lawyer to the defendant. The hourly rate is the basis that most charge from. They bill their client a set amount for each hour or fraction of an hour that they spend on the case. And the hourly rate can range from a low of about $150 to $800 or even more, depending on the lawyer's reputation, skill, and specialty. In addition, the client may also have to pay for other expenses, such as paralegal fees, court fees, filing fees, copying fees, travel costs, and expert witness fees, and more. Whether you win or whether you lose, this is the minimum amount of cost that you will have as a defendant. If you work for a private, public, or corporate hospital, you will find that the hospital is responsible for the actions of its employees who are acting within the scope of their employment and authority. A hospital lawyer is a legal professional who represents the hospital in various matters, such as contracts, compliance, litigation, and risk management. A hospital lawyer may have some responsibility for employee errors, but this is not always the case, depending on the circumstances and the nature of the error. Since we're looking at medical imaging, we'll take a look at radiologist, or the physician that is in charge of many of the departments. Approximately 31% of all practicing radiologists will get sued for malpractice at least once in their careers. However, this does not mean that all these lawsuits are successful or justified. But over 80% of radiology malpractice lawsuits end up in an out-of-court settlement, which may indicate that the plaintiffs are not confident in their chances of winning a trial. Since medical imaging technologists gather the data to create the images that the radiologists interpret, they should be involved in many of these lawsuits. In addition, many radiologists actually do not get informed consent personally from the patients. It is done by the technologist or the front desk in the medical imaging department. So there again, we have somebody that's going to be involved that is not the radiologist. The other areas, failure to treat or follow safety procedures or errors in medication, are fairly small. The only one that was really left is the patient was not given proper education. And again, a lot of times the radiologist is not going to educate the patient, but the ancillary staff in medical imaging is. In addition to what the radiologist is being sued for, think about all of the interactions you have with patients that could result in patient injury and what you might be able to be sued for as well. Medical imaging technologists, as part of the radiology team, may also be liable for any mistakes or oversights that result in harm or injury to a patient. Fortunately, lawsuits against medical imaging technologists are far and few between. Even so, it does not mean that you cannot be involved in a lawsuit with the hospital, with the physician, or on your own. In a state court of appeals, it was found that both the hospital and the radiology technician, which should be medical imaging technologists, are capable of medical malpractice because the hospital is a licensed healthcare facility and the radiology tech or medical imaging tech is an employee of a licensed healthcare facility engaged in assisting with medical care and treatment. A simple rule of thumb to observe is people pursue lawsuits for those they dislike and do not tend to pursue lawsuits if they feel that their treatment was worthwhile and of value to them. Patients are less likely to bring a lawsuit against a person they trust and respect. Interactions with patients should reflect the cultivation of your communication and professional manner. You should treat your patients with respect, compassion, empathy, and professionalism. Communicate clearly and effectively with the family and the patient. Positive interaction with patients can help you build your rapport and trust. The probability of a medical imaging tech being sued for malpractice may depend on several factors, such as the type and severity of the error, the harm caused to the patient, state laws and regulations, and the availability of quality legal representation. One of the biggest problems we have in medical imaging is the patient's knowledge of ionizing radiation. The general public has a great fear of ionizing radiation and exposure. Taking time to talk with and educate your patient may lessen this fear of ionizing radiation exposure. Communication and patient education are just some of the things that a good medical imaging technologist should practice. Let's take a look at some of the imaging tips that might help you in the long run avoid being sued for malpractice as a medical imaging technologist. Medical malpractice occurs when a healthcare provider fails to meet the standard of care expected in their field and causes harm or injury to a patient. You may want to take time and look at the ARRT, Professional Standards and Ethics, which will help you understand the scope of practice that you work under. The moment you engage with your patient, you are responsible for that patient and their safety. One of the biggest safety factors that you can use to protect yourself against any type of accusation is to document everything you do thoroughly, because if you don't document it, it didn't happen. You can actually make annotations in the electronic image file or utilize documents provided for the patient, such as their requests to put down your observations. Let's take a look at the different types of consent. Remember, you cannot do anything to a patient unless they consent to it. We have informed consent, we have implied consent, and we have express consent. Most of the time we'll be dealing with implied consent. Implied consent is provided by the patient and their behavior. So when they present at the outpatient clinic, go to the x-ray room, and stand up to get their chest x-ray done, that is implied consent. Express consent is anything other than implied consent. And express consent may be oral or it can be written. Informed consent may be the form you use anytime you're using some sort of contrast media that can cause a reaction to your patient. Informed consent must be obtained after a reasonable explanation of the proposed procedure to the patient so that he or she is enabled to make informed decisions whether or not to submit. If the patient says no, that's a no. Before performing any imaging test, you should explain to the patient what the procedure involves, what are the benefits and risks, and what are the alternatives. You should also answer any questions the patient may have about their written consent. Informed consent can help you avoid claims of negligence or lack of communication. With the rapid changes in technology and the complexity of the exams becoming more intricate, we need to be able to invest in continuing medical education to upgrade or adapt our skills and knowledge level to keep current with the field. Continuing education can help you to improve your performance and avoid errors or mistakes. It can also help you move forward in your career path. We'll talk here just a little bit about ethics and professionalism. But if you would like, I have several different presentations on ethics that are more detailed and professionalism on my YouTube channel, Mark Struthers. As a medical imaging technologist, you need to adhere to the ethical code of conduct and the scope of practice of your profession. The scope of practice is what you're allowed and trained to do, not what you're asked to do. Respect the rights, privacy, and dignity of your patients, especially when you're dealing with cultural differences. I have many presentations on different cultures and their perspectives on healthcare in the United States. This may help you in dealing with a person from another culture. Protect confidential information and follow the HIPAA regulations. Avoid any conflicts of interest or inappropriate relationships with your patients or your colleagues. If you have a problem, you need to report any errors or incidences to your supervisor or manager so that you can resolve the problem. If you didn't say anything, then you didn't do anything. If you have to repeat an exam, let the supervisor know you need to repeat an exam and why, and you're covered. You should not surreptitiously delete exams and not let anyone know. You may think you're looking good, but you're not. Finally, we'll look at cost of insurance coverage compared to other healthcare professionals and the benefits of having malpractice insurance if you choose to have malpractice insurance. The cost of malpractice insurance for imaging technologists may vary depending on a number of factors, such as the type and amount of coverage, the state and the location of the practice, and the level of experience and education. Current sources suggest that the average annual premium for X-ray technologists or medical imaging technologists ranges from $200 a year to $500 a year, which, when compared to other professions, is very low. Let's review some of the possible benefits of coverage with insurance. You can get coverage options up to $2 million per claim. You can also get full consent to settle claims. You're covered for telemedicine and telehealth. You're covered for license defense, and you're covered for general liability. The coverage is 24/7, and it is portable. You can use it everywhere you even volunteer, do telehealth, per diem, or moonlighting assignments, as well as on your job. Some common examples of malpractice claims against medical imaging technologists are failing to properly position or monitor a patient during an examination and leading to a fall, burn, or other injury, failing to properly operate or maintain the imaging equipment, resulting in poor image quality, radiation exposure, or equipment malfunction, failing to properly label, store, or transmit the images, causing misdiagnosis, a delayed diagnosis, or loss of data, and also failing to communicate effectively with the supervising physician, patient, or other healthcare professionals. Know your responsibilities and practice ethics and patients' rights relevant to the field of diagnostic imaging and the role of the imaging professional. Thank you for your time and attention. We all kind of worry about malpractice and medical liability, and if you want to find out more information, take a look on my YouTube channel, Mark Struthers, for many presentations that support and expand on the information that you find in this presentation.